Hello everyone. Alright, it's been a bit of a disaster this morning. I made this PowerPoint, which is like 15-20 slides, and for the life of me, I cannot find it on the computer. So I'm going to work straight off the PDF file. Bit of a disaster. I've been looking for it the last 45 minutes. Right, so anyway, the rules and theory of the contract. You guys might think this is a tricky chapter. The reality of this chapter is it's a mishmash chapter. Alright, so when you're revising for this, very simply, if you look here, after reading this chapter, you should be able to, you've got three sections, haven't you? 1, 2, and 3, yeah? Understand the rules and principles of contract. Now, the beauty of that is, because you've already studied the whole of contract, you know what that is. You know formation, terms, vitiating factors, discharge, and associated remedies. So that is not a problem. And then it goes on to say, have a basic understanding of theory of law of contract, and then analyse and evaluate. I'll tell you what, a very fast way to do this chapter. You already have a broad understanding of this because you should have studied all the chapters. Again, with this, you've already got that. That's offer and acceptance and that kind of thing. It's actually this bit we're after, the analysis and the evaluation of the voluntary nature of a contract. So when you start flicking through this chapter, the rules and principles of contract law, you don't need that introduction because you've studied the rest of it, right? So it goes on, basically talking about formation, right? And the bit which is important in the next page or so is just one concept: the freedom of contract. Yeah, the freedom of contract. So if you look here, the theory of law, or the theory of the law of contract, the usual principle of common law is the freedom of contract. You see that concept there? That is the concept that you need to know about. Yeah. So from an examination point of view, that's if there was a 15 marker, they might ask about the concept of freedom of contract. Yeah. So the freedom of contract is essentially this, isn't it? A promise or set of promises which the law will enforce. Okay. And essentially, contract law should allow that to occur. It should allow promises to be set and promises to be abided by. Now, it's not always that simple at all. You know that already. Well, you've got the Consumer Rights Act. Yeah, that's giving the consumer rights against an unfair contract. So technically, you could argue that's not freedom of contract because you're not free to contract how you want because there are constraints of the Consumer Rights Act. Yeah, so you can see already how this is going to pan out. You've got the idea of you can contract how you want and what you want versus the law and its operation in other spheres. What do I mean by that? Well, look at law and morality. Yeah, the idea of law being moral. Well, if you look at purely the concept of freedom of contract, that and law and morality, they can be at odds of each other because freedom of contract is suggesting you can contract how you want. Law and morality saying no, that the law should be moral. Well, then contract should also be moral according to law and morality. Yeah? Let's have a look at the idea of balancing conflicting interests. What's the idea of balancing conflicting interests? The idea of fairness between two parties, yeah? The claimant and the defendant. Well, the freedom of contract saying you can promise what you want, you can accept what you want. But balancing conflicting interests is a concept which allows the court to intervene to allow conflicting interests to be settled. So you could argue also that balancing conflicting interests is worth evaluating against the idea of freedom of contract. Yeah. So as this chapter goes on, don't freak out. It's actually quite straightforward. All right, at this point, I'm going to stop for a second. I can't edit this video, so you might have to play it back to yourself a few times. Yeah, ideally it should go in linear fashion. It won't. I'm going to do this the fastest possible way so you don't stress out. Okay. So if I go through this now, it says, look, under the theory of contract is based on promising. That's nothing new to you. It's just talking about the idea of promise and consideration and so on. Yeah. So it says here, the argument against allowing past consideration. Yeah. Oh God, that's gone wonky, isn't it? The argument against allowing past consideration. Okay, I ain't gonna bother fixing that. All right, as a valid form of consideration is made to prevent opening the floodgate for dubious cases. Yeah. So that's there. Well, then you could say, well, in the contract we should allow past consideration, because under freedom of contract, why does when consideration occur, why is that important? Yeah, and obviously it is important, otherwise everyone could claim for everything. Okay, so it goes on to say bigger cases tend to result on the basis of commercial reality and expectation of payment of a reasonable sum on the basis of quantum merit, right, which might be agreed after the event. It's interesting to compare McCardle with the implied promise, as in, yeah, it's not that interesting to compare that, yeah. So this is the issue with this chapter. It's quite random. The structure is quite poor. Yeah. So what do you need to know up to now? The idea of freedom of contract and how other parts of the law can be at odds with it. Yeah. So we've got consideration as something that could be at odds with it. Yeah. So it goes on in the chapter, and they start going to cases. Yeah. Whichever theory is considered agreed terms must be certain. What are they talking about there? They're just talking about the formation of a contract, yeah, and the properties of formation of a good solid contract, which you already know about, yeah. Now, as this goes on, they start looking at a few cases. So they look at butter machine tool and so on, right? And what are they trying to get at here? Well, this is it. Get that waffle, go straight to Lord Denning. Lord Denning is suggesting that the subjective view. Oh God, I've got this OCD thing. Okay, Lord Denning is suggesting that the subjective view of the contract terms that the parties to the contract have been replaced by an objective view that the parties must have agreed. Yeah? Alright, this is an example of the courts concluding what the terms of the contract actually were from the dealings of the party. Well, technically, you can use that and say, look, there is freedom of contract, but there are limits to that freedom of contract. Yeah, and you don't have to go through the details of this particular case. You just mention that case, mention Lord Denning, then say that there is a replacement from a subjective view by an objective view. A subjective view is more supporting the concept of freedom of contract. An objective view is something where they're not actually looking at what the parties thought they were getting into. Yeah, so you could use that as a small argument to say, yeah, there is freedom of contract, but a limitation is that the courts take an objective test and use Lord Denning in Butler. Yeah, moving on. Implied terms are also played in the contract, and neither party may have agreed. Yeah, that's beautiful. So now you've got 2 points that are perhaps limiting the freedom of contract. You could argue implied terms. Yeah. So you've got 2 things now. You've got what Lord Denning said in Butler, and now you've got implied terms. Make sure you're writing notes. My actual PowerPoint had all this broken down, which is a bit of a shame. Okay, so implied terms also placed in a contract, neither party may have agreed. Well, if they've not agreed it, then how is there freedom of contract? That's the argument. In Marks and Spencer, PLC and BNP, right, Lord Neuberger, and you know how they love the names of judges in an exam, emphasised that construing express word of contract is a different exercise from implied words which are not to be construed. Yeah, you don't need to remember that. All you need to remember is this: implied terms are also that neither party agreed, and this was confirmed by Lord Neuberger. That's what you write in the exam. Okay, and then here is the free analysis, and you take this analysis and you repeat it in the exam. Okay, you just turn around and say, look, this is moving away from the idea that the contract is freely negotiated. Yeah, brilliant. So here you have it. You have a few points there that you can include in your exam. Yeah, 1, 2, and then look, here's your analysis here. I'd like to write AO2, but this pen is really fat. Right. The courts will be very careful when departing from the common law principle of freedom of contract. Yes, they will therefore be reluctant to imply terms into contracts. So now they're saying, look, yeah, the courts can intervene, however, they are reluctant because of the principle of freedom of contract. Again, that's an AO2 you can write. Yeah, that's supposed to be AO2 somehow. It could be argued that the courts try to avoid this because of the long debated criticism of judge-made law. What are they trying to get at? You know all this. This is just stuff you literally memorise, right, for the exam, because it's all analysis and it all makes you sound Like you can do your AO2 and AO3. What is the actual point? You probably think it's simple. If the courts keep construing the implied terms, then there's more lawmaking power given to judges. That's the argument. Yeah. Hence, it could be argued that the courts try to avoid this because of long debated criticism of judge-made law and the argument that Parliament should make changes to the law. Yeah. So why are judges making all these changes? Yeah, they're not elected. Essentially, Parliament should be making changes to the law. It goes on to say, however, when Parliament changes the law, we tend to get a confusing situation with a clarity and extension of rights in one situation, and then that's it. And then they go on to the Consumer Rights Act. Yeah, there you go. All right, and then look, another point. So look, you don't need to freak out. You got 1 point Butler. You got 2 point here, Lord Denning, and Lord Denning's point. They give you loads. They give you another point of Lord Nuremberg, but they give you the analysis on a plate for you. It then goes on, if you look here, freedom of contract is eroded when Parliament. So there's another point, your third point in your essay for freedom of contract. Freedom of contract is eroded when Parliament creates an act that implies a term in the contract. Yeah. At one extreme, the Consumer Rights Act 2015 inserts terms and rights and remedies that cannot be excluded by a business. That is a very strong example of the freedom of contract being contravened and effective, not in a negative way. You'd say it's not. You can't say it's central. You could argue that Consumer Rights Act has more power now, yeah, because it can insert terms. Look, insert these terms, insert rights, insert remedies, which are not excluded by. Well, where's their freedom of contract? That's your argument. Where is their freedom of contract? If in the Consumer Rights Act they're literally dictating parts of the contract for you, yeah. And then you can talk about the Sales of Goods Act as well, right? So you've got 3 chunky points there for your essay of freedom of contract. How would I structure it? First, you define the freedom of contract. Yeah, you go back here, you define the freedom of contract. You know, you present it as a romantic idea in an idealistic form, yeah? And then you slowly start to dismantle it by using these points here. Simple. So you've got day before the exam, you just literally learn the essay plan. Okay? It goes here on to say the traditional use of conditions and warranties promotes certainty. If a condition is breached and a contract has not been fully performed, then it may be terminated. But if it's a warranty, there's no right to terminate. This approach is inflexible and can lead to unfair results. Yeah? So really that is talking about conditions and warranties in relation to freedom of contract. So it's saying that how you phrase something to be a condition or a warranty can affect the freedom of contract because it affects the outcome. Yeah? And it goes on to say a minor breach of condition gives a right to terminate the contract. Yeah? So let's have a look at this point in entirety and see how it fit in the essay. This is always the case except where there's a contract sales of goods, section 58, blah, blah, blah. This is where the buyer has a right to reject. So I'm still looking for my point in the essay, which I've not found, but the breach is so slight it would remain unreasonable from, yeah, in this case the breach is not to be treated as a breach of condition, but may be treated as a breach of warranty. So what? Let's carry on. There is, however, an exception to this exception. This section applies the unnecessary contrary intention that appears in or implies from the contract. What a mouthful. Presumably this means the term of the contract stating all the terms expressified are to be treated as conditions would then nullify this section of Sales of Goods Act. Okay, all it's giving is a counter argument here to the Sales of Goods Act, saying that essentially conditions and warranties cover that. That's a really complicated way of making a very simple and minor point for your essay. This is not a massive point for your essay. These points here, they're huge. Okay? These points are huge. If the day before the exam you don't understand that, don't freak out. Yeah? Right, now, moving on, it goes on to a similar effect is produced, however, innocent party suffers a major breach, no termination is possible. The nominate term is less certain, it can be difficult to decide the breach is insufficient to justify termination. This important in relation to remedies available, and it means that party reports to terminate. Okay, this is why I said the structure of this the actual chapter's poor. They've actually moved away now. They've moved away from the essay of looking at freedom of contract. They've started going back into general principles of contract. Yeah? So, now we're going to look at implied this term. Implied terms are default terms. Yeah? And we're going to go into that. So I'm going to stop this video. That gives you the first bit of that essay. It should be nice and clear. I'm going to see if this did not record, I'm going to be very disappointed.